I've got 35.8 million reasons why you need to start paying your employees properly under federal law. I'm Karen Michael, and you're listening to The Job Judge. Welcome to The Job Judge, the podcast for anyone who works. I'm Karen Michael, your host of The Job Judge, where every single week we navigate through all those legal landmines and workplace dysfunction with the goal that one episode at a time, we are going to make workplaces work for you and for everyone that works there. Now, a couple ground rules. I am an employment lawyer, but of course I cannot give legal advice on this podcast. This is just general guidance. And sometimes we talk about sensitive subjects on the podcast, not necessarily today, but frequently. So be warned if you're listening to other episodes in the car. And then finally, you're not going to want to miss an episode of The Job Judge. So go ahead, hit the subscribe button, like, comment, share this information, because anyone who works deserves to know what their rights are in an organization, and employers, you need to know what your obligations are. Let's talk about this whopping verdict. So there's this law. It's an old-fashioned dinosaur of a law, and it's called the Fair Labor Standards Act. And this thing went into effect in 1938, and there hasn't been a whole lot of changes since then. Imagine how we worked in 1938 and how much has changed. But this law, not so much. And even though this law has been around forever, employers don't understand it, don't comply with it. I could probably walk into any organization today and find FLSA violations. And there's a lot of reasons for that. Number one, we want to make everybody exempt from overtime. And under this federal law, all non-exempt employees must be paid time and a half of their regular rate of pay for all hours worked over 40 in a work week. And employees are entitled to be paid for all working time. Now, there is a category of employees called exempt. That means they're exempt from all these rules under the Fair Labor Standards Act, all this overtime provisions, and all these employers want to make everybody exempt. They don't want to make anybody non-exempt because it's a hassle and it's expensive to have to pay overtime and keep track of time and all those things. So they misclassify employees as exempt when they're really non-exempt. And I see it all the time. Yeah, Jane, she's a team lead. And even though she doesn't have any supervisory responsibilities, and even though her main job is to care for residents or to run the cash register, we're just going to make her exempt from overtime. And so all those hours that Jane is working, over 40 that you're not giving her overtime, those hours are racking up because all this time she was entitled to overtime. And who is actually exempt from the Fair Labor Standards Act? Again, go back to 1938. It makes no sense at all. The law is completely complicated and gobbledygook, and our Congress they never want to fix it. There have been multiple opportunities to fix this law, and no one seems to want to do it. So we're stuck with this. So understand, this is the law we have with all the complications and all of that. And if you're an employer, you have to follow it. And this employer failed to do so. So the Department of Labor announced at the end of July 2024 that it obtained a huge verdict against a healthcare company to the tune of $35.8 million. And this is what the news release from the Department of Labor says. In one of the nation's largest wage recovery judgments, a Pennsylvania federal court, after I believe it was a 13-day bench trial, meaning just a judge was on there, not a jury, has awarded $35.8 million in overtime back wages and liquidated damages, we'll talk about that in a second, to 6,000 current and former workers employed by the operators of 15 residential skilled nursing, rehabilitation, and assisted living facilities in Western Pennsylvania that willfully denied them overtime pay. And so the verdict was to pay these employees back pay to the tune of $17,902,219.10, but to also pay something called liquidated damages, which is double what was owed. So now this employer must pay not just the back wages, but also what's called liquidated damages in the same amount. So an additional $17,902,219.10. What did the employer do? Well, one of the things that this employer did that I see way too often is willfully failing to pay employees for all hours worked, including work done during meal breaks. There is a huge misconception about breaks and meal periods in our workplaces. Under federal law, there's actually no requirement that an employer provide an employee a break or a meal period. Now, there are some states that require breaks and meal periods after a certain number of hours in a day, and you can find that map on the Department of Labor's website, the Wage and Hour Division, Department of Labor Wage and Hour Division's website. But if you do provide a break or breaks or meal periods to your employees, and I hope you do, if you do provide that, there are actually rules around the compensation of breaks and meal periods. So, for example, I had this client where they had a woman that had a lot of smoke breaks, and they were frustrated with how many smoke breaks she took. So one thing they said to her is, Sally, when you go to your smoke break, you have to clock in and out. She was a non-exempt employee. You have to clock in and out. So she would go out for 5 minutes here, 10 minutes there, 5 minutes here, 15 minutes there, all day long, clocking in and out. That wasn't legal because according to federal law, breaks of short duration, generally under 20 minutes, those breaks are compensable, meaning you have to pay for them. You can't require an employee to clock in and out. Now, there are certain exceptions. There's an exception under the Pump Act if somebody is lactating and they take more than their normal breaks, beyond the normal breaks that you give. There's some provision that you can reduce pay for that. There's some provisions under the Family Medical Leave Act, even for an exempt employee. So there are some exceptions. But in general, short breaks are compensable. So while you're not required to give them, if you do, you have to pay for that time. Now, you can set rules around it. You can only take a 15-minute break. You can't take more than 15 minutes. If the employee takes more than 15 minutes, you can discipline that employee for taking more than 15 minutes. But understand that these short breaks are compensable. Now let's talk about meal periods. Under federal law, a full meal period is only not compensable, meaning the employee has to clock in and out or doesn't get paid for it, if the employee is fully relieved of duty for 30 minutes or more. Generally speaking, if an employee is fully relieved of duty for 30 minutes or more, you are not required to pay that employee for that meal period. But here's what happens. Jane goes to her lunch at 12 o'clock. At 12:10, Jane's interrupted, and they say, hey, the resident in room 13B needs your attention. And Jane's the only one that can give this IV or this shot or whatever it is. So Jane, who's a caregiver, let's say she's a CNA, goes in to assist with this resident. And she's gone for, let's say, 6 minutes. She comes back to finish her meal period at 12:16. So she starts her meal period at 12. She leaves at 12:10. She goes and assists with the resident at 12:16 and then returns. Employers wrongly believe that they have to provide her the balance of that 30 minutes in order for that time to not be compensated. Or they wrongly believe that when she's done with her meal period at 12:30, that all that time is unpaid, even though for 6 minutes she was doing some work. This is how the law works. When she took her meal period from 12 to 12:10, that's nothing more than a break because she was interrupted. She went and did work. So now when she returns to her meal period at 12:16, the only way that time is not compensable, meaning she doesn't get paid, is if she gets a reset. Her meal period now starts at 12:16 from when the last time she was not interrupted. But when we're interrupting our people during their meal period, or we're expecting them to work during their meal period, or they're a receptionist waiting for people to come in. So maybe nobody does come in during that 30 minutes, but they're there working. They're waiting for someone to come in. They're waiting for the phone to ring. That's not being fully relieved of your duty. And a place like this, a residential facility that's probably got a lot going on, maybe understaffed, who knows, and they're really busy and it's hard to even get a break or a meal period as it is. Under those scenarios, this is ripe for this kind of problem to happen. And it's not a matter of did they get their breaks or not. It's a matter of were they paid properly when they went on their breaks and meal periods. And you can see how this adds up without putting processes in place to make sure that employees are paid for all hours worked in a work week. The other misconception is overtime. So if an employee works 35 hours this week and 45 hours next week, but within the same pay period, employers wrongly believe that that employee worked 80 hours in the pay period and therefore that employee is not entitled to overtime. That's not how it works. That employee was entitled to 35 hours of compensation in the first week and 45 hours of compensation in the second week, which includes 5 hours of overtime compensation for that extra time. So you don't look at anything in a pay period. You look, everything is based on a work week. That's just how this FLSA was created. It's a dinosaur. I understand. I don't make the rules, but those are the rules. And you can see how you can get tripped up. My advice to employers: please make sure that your employees are properly classified as exempt from overtime if they are. There's a tiny, limited number of people where that qualifies, and it's a very narrow group of people. I go into organizations, they're like, oh, everybody's exempt here. What? No, they're not. It should be a tiny, narrow group of people, and there are very specific rules. And it's not based on necessarily pay, although there's a baseline. It's also and mainly based on the duties that that person is performing, the actual job itself. Not what's in the job description, by the way, but what they're actually doing. So you might say, well, this employee, customarily and regularly oversees the work, directs the work of 2 or more people. But for the last year, this employee the team has been diminished. Now she's only got one person reporting to her. Well, now she's lost the executive exemption for a whole year. So you always have to be evaluating whether or not people are properly classified. And then for our non-exempt employees, you need to know the rules because our employees are entitled to be paid for all hours worked. So you need to understand what is working time. When is their on-call time paid? What's premium pay? What's a non-discretionary bonus? And how does that tie into the regular rate of pay? What about travel time? What about time in training? When is it working time? You have a mandatory lunch where you require everybody to come in for a big team meeting over lunch. That's working time. Or mandatory training before, oh, well, they just came in for 30 minutes before work. That's working time. If you make an employee come in a half hour before working time for a staff meeting, that's working time. We don't pay people their scheduled hours. We pay people their working time, their working hours. So we have to make sure we get this correct. And if you look at verdicts and judgments under the Fair Labor Standards Act, they're large, in part because of the liquidated damages. And oh, by the way, if a private attorney had brought this lawsuit, that attorney would also be entitled to attorney's fees. So when your terminated employee goes to the lawyer down the street and complains about being fired, that lawyer is not really asking about wrongful termination or harassment. That employer wants to know, how were you paid? What was your job? Well, how many other people are in that same job? Oh, you were an IT technician and you were exempt. How many hours did you work in a work week? Oh, 50. Well, how many other people are in that same job? Oh, 10 people. So now I've got 10 people who all were wrongly classified as exempt. They were non-exempt because their job was to come in and fix computers. That's a non-exempt job according to federal law. And now they all worked 10 hours of overtime for how long? That's going to add up. And that attorney isn't going to send you a demand letter. That attorney's just going to go file suit in court demanding this compensation, because that attorney knows no matter what, if they get any money in that lawsuit, they're going to get their attorney's fees. So it is a huge risk area. And why wouldn't you pay your employees fairly? That should just be something you do as an employer. Our employees work hard. They deserve their compensation for all their hours worked. Now it's time to ask the job judge, where I read a question I get from a listener, or an email that I get, or I find something on social media, and I'll read the question and then I'll be the judge of that. I'll let you know exactly what I think. Now, if you'd like for me to answer a question here on the podcast, be sure to email me, Karen at thejobjudge.net. That's Karen at thejobjudge.net. And I just might answer your question right here on the podcast. This comes from someone who posted on Ask HR on Reddit. And this person writes the following. He's a salaried manager of a store for a company that is expanding. He was offered an opportunity to go out there and teach and train new employees. His issue is that he just found out about an hour ago. He says, I will be sharing a room with an hourly employee while I am there. I know the young guy, but not well enough to feel comfortable sharing a room with him. Also, the liability that I open myself up to by alone makes me uncomfortable. I was told previously that we were going to be staying in separate hotels from hourly staff because they were worried about commingling between the staff and management because of the last trip. Goodness knows what happened there. They went in the opposite direction here. Also, the company travel and reimbursement policy states that salaried managers get a room at a minimum rate of $140 per day. And the price doesn't bother him, but he looked up the hotel and they're splitting $120 a night. So basically they're getting a deal and they're not having to pay for a full hotel room. This person says, I know this is an HR matter, but the person who sent me the details is our head of HR. Can you imagine? I feel like if I say something, they're going to take away the trip from me. And I've worked a lot of extra on top of a full-time schedule in order to prepare for the trip. What are my options? Well, there are no necessarily legal options that you can raise in this situation. But do I think it's a good idea to have employees, to require that employees share a hotel room? Absolutely not. That's a hard pass. That's a no from me. I vehemently disagree that an employer should require employees to spend the night together in a hotel room. It's such an intimate and familiar setting. You're putting on your pajamas, you're getting ready for bed, you're using the bathroom. All of these things are things. You're sleeping next to somebody. That's not appropriate. In this day and age, we should not tolerate or require that, whether it's employees that are hourly, managerial, we should not be requiring that. And I'm just going to tell you this one story just to highlight why I feel so strongly about this. And there's multiple examples, though. I was doing a training for an organization, and after my training, a manager, an executive came up to me and he said, I've never told anyone this story, but I want to tell you something that happened to me and I want your opinion of it. And he went on to tell me that years and years ago, probably over a decade or two ago, they were required to share hotel rooms. And he shared a hotel room with this other man. And he said in the morning, this man got up to use the restroom and he came back, stood next to his bed, got naked, climbed in the bed with him, and started to cuddle with him. This executive shared with me that he literally went numb. He did not know what to do. He just kind of laid there still. And finally, the guy got up, got ready, and they never spoke about it. And this man tells me he's never told anyone this story, but he wanted to know what I thought about it. And I looked at the look on this man's face and I said, you experienced a trauma. You're traumatized. I can hear it in your voice. I can see it in your face. And the fact that you've never told anyone about it, you've kept it inside all these years, tells me how traumatic that was. We cannot assume that because it's two men or two women. By the way, what about people that are attracted to the same sex? How is there an assumption that if people are the same gender, that somehow there isn't going to be something inappropriate or harassing that happens in that hotel room? You should never, ever require that employees share a hotel room. But when you're requiring an employee to share a hotel room, that's a hard no. Now, we drop an episode every single week here on The Job Judge. Be sure to like, subscribe, follow, comment. You don't want to miss an episode. I'm Karen Michael, and you've been listening to The Job Judge.